So again, today we are focused on powers of attorney. And when we talk about powers of attorney, there really are two big kinds of powers of attorney. We have financial powers of attorney, often called durable powers of attorney or statutory durable powers of attorney, and then also medical or healthcare powers of attorney. So we'll go through both of those today and talk about the differences and how they work. So starting out with financial powers of attorney. Generally, you need to understand that a financial power of attorney, or just a durable power of attorney, enables your agent, your representative, to be able to handle financial matters for you or business matters. Anything relating to your business, your stuff, is covered by a durable or financial power of attorney as opposed to the medical power of attorney that we'll talk about later. Understand as we go through today's discussion, when I refer to the principal is the person who signs the power of attorney, whose power of attorney it is. So if you do a financial power of attorney, you are the principal. And then when I refer to agent, the agent is the person who's representing, who's empowered, so to speak, with that power of attorney, who's representing the person who signed the power of attorney. So that's the agent. As we go through our discussion today, just be aware that as we kind of go through this discussion, we're going to talk with financial powers of attorney about general versus special powers of attorney. Then we'll talk about what that term durable means. So a durable power of attorney, what is that? What does that mean? We'll talk about the effective dates or effective times of durable powers of attorney, and also decisions that you need to make with regard to your agents. And again, when I refer to agents, I'm talking about your representatives. So focusing first on general versus special powers of attorney. A general durable power of attorney is meant to be one that's kind of global. It's intended to cover a very wide range of transactions. So generally when you do a power of attorney for estate planning purposes, the power of attorney you do will be what we call a general power of attorney. Now that's distinguished from a special power of attorney. A special power of attorney is one that's intended to be very narrow. For example, it might be restricted to transactions with a particular brokerage house. I might have a brokerage account with someone and a special power of attorney that allows someone just to deal with those accounts. Or it could be limited to a particular transaction. So let's say I have a closing set for real estate, but I know I won't be available to handle that closing. I might do a special power of attorney that allows my representative, my agent, the authority just to handle that one transaction. So again, a special power of attorney is limited to a particular transaction or a particular type of transactions, whereas a general power of attorney is one that's meant to be a more global, universal power of attorney, and that's what you'll typically have in the context of estate planning. Now, when we talk about the powers that a power of attorney conveys, we'll talk in a few minutes about what's covered under a power of attorney. So we'll get into the general powers, the general breadth, so to speak, of a power of attorney in a few minutes. So turning our attention now to durability. What makes a power of attorney durable? A durable power of attorney is one that remains effective even after a person loses capacity. So if I sign a power of attorney, perhaps it's effective now, but if it's not durable, if I lose capacity, if I lose the ability to handle my own financial matters, then my power of attorney evaporates as well. It's no longer effective if it's not durable. And in Texas, we have to have special language that makes a power of attorney durable. So very often when we talk about powers of attorney, we just say general durable power of attorney or statutory durable power of attorney, because we assume that every power of attorney needs to be durable. It's really when we lose capacity that it's most important to have a power of attorney. Here's the catch. Sometimes people try to economize or do things simply and perhaps get online and find a form for a power of attorney, but if it's not a Texas power of attorney, or if it's not prepared by an attorney who understands the need for a durable power of attorney, then it may lack the language that's necessary to make it durable. And if your power of attorney is not durable, if you lose capacity, then your power of attorney is no longer effective and your agent, your representative, does not have power to do business for you. So it's very, very important that your power of attorney have some kind of language saying specifically, this is a durable power of attorney, or some language to the effect that this power of attorney is not affected by my later incapacity. Something along those lines will make it durable under Texas law. If you're not sure whether your power of attorney is effective or, pardon me, durable, you need to check with an attorney to make sure it is. If it's prepared by our firm or most other attorneys in Texas, be assured that it is a durable power of attorney. All right, shifting our attention to the effective date. So when is your power of attorney effective? A power of attorney can be effective either immediately, or it can be what we call a springing power of attorney that springs to effect later. Now, an immediate power of attorney, if I sign it and give it to my agent, my representative, they have the authority to handle financial matters for me right away. Whereas if I have a springing power of attorney, then my springing power of attorney had no effect while I was well, but once I lose capacity and that incapacity is verified by a physician in writing, according to the terms of my power of attorney, that's when my representative's power springs to effect, and that's when my power of attorney is finally effective. Now, a lot of people, when we talk about this difference between an immediate power of attorney and a springing power of attorney, kind of their immediate reaction is, well, I want springing because I don't want anyone messing with my business while I'm well enough to do it myself. But that's a little bit awry of what we often recommend for clients. Often we recommend that a power of attorney be effective immediately. And that's often because it's hard to distinguish when a person loses capacity. Now, if I have a traumatic event, even a stroke or an accident, something where there's a defining moment of incapacity, then it's very clear that I had capacity one moment and I lost it the next, and it's very defined when my agent's power springs into effect. But for many of us, incapacity is a gradual process. So perhaps I have full capacity now, but as I age or as a disease affects me, maybe I start losing capacity. Maybe I have the ability to handle some aspects of my decision making, but not others. And it becomes very murky when I do or do not have capacity. And likewise, it can be very difficult to get a physician to certify in writing when I've lost capacity. And in those cases where someone's capacity perhaps comes and goes according to the time of day or the type of decision to be made, it can be very unclear when an agent has authority to act on behalf of the principal. So especially as clients are aging, especially then, but often for clients of all ages, we recommend an immediate power of attorney. Now, this brings to light a factor that you need to be aware of throughout your planning, in that you need to make sure you have absolute confidence in the ability and the integrity of your agent. You have to have the confidence that your representative, the person you've named, is looking out for you and that they truly have the ability to manage your assets the way they need to be managed. If you lack confidence in your agent, then perhaps it's not the right agent. So generally, we recommend an immediate power of attorney as opposed to a springing power of attorney. Look at your power of attorney and see when it's effective. Often we run into problems with clients who have springing powers of attorney. All right, the final issue that we want to talk about on this list is the agent. Who do we have named as our agent? Now, again, the agent is the person you have named as your representative, the person who can handle financial matters for you. And one common question is, who do I name? We recommend that you name a sequence of agents. So perhaps, for example, in my family, it would be my spouse first. And if my spouse can't act on my behalf, then I would go through a series of backup agents or representatives. Another question we have is, can I name my kids as co-agents? I don't want to choose, or my kids travel a lot and I never know who might be available to handle decisions for me. And in those cases, it is fine to name co-agents on your financial power of attorney, but we do have to make the decision, do they have to act jointly or can they each act independently? We can do it either way, but we have to know how you want it so that we can draft it accordingly. But I want you to understand that if we have co-agents, we've not made it simpler for them. Sometimes people want to have co-agents so no one gets their feelings hurt. But by having co-agents, we really are making it more difficult, more onerous on those two representatives, because then they have to get together to get anything done. They're doing it together. Whereas if we have independent agents, well, this one's available, he can take care of something. If he's not available, but she is, then she can take care of it. But it's very, very important that you make sure that they get along, that they're not riding over each other and one's doing something and the other one's undoing it. they need to be able to act independently. So typically we recommend that joint agents be allowed to act independently as opposed to having to act jointly in getting things done. All right. A few minutes ago, I promised that we would look at that list of standard powers. So with a durable power of attorney, what can your agent or your representative typically do? And if we're looking at a statutory durable power of attorney, a statutory durable power of attorney simply means that it's following generally the format that's set out in the Texas law for what we call a statutory power of attorney. And the statutory power of attorney has this list of powers, and you'll see that it looks like it covers everything fathomable, everything that would affect you, and many things that perhaps don't affect you, but it goes through real estate transactions and personal property transactions and banking and retirement and beneficiary transactions. It goes through a full list. And typically with this list, we recommend that clients initial O, that final option, which gives the representative, the agent, the authority to do all of the above. Now, granted, most of us don't have something or have assets that fit every one of these categories. Nonetheless, I don't recommend that you go through and delineate item by item. Again, we just recommend O to cover all of the above. But even though it looks like that list covers everything under the sun, there are certain statutory and case law exceptions where over time, Texas law has said, okay, it looks like this covers everything, but it doesn't cover this, or it doesn't cover that. And the law has carved out exceptions saying that an agent under a power of attorney, even one that looks as global as this list, doesn't automatically have certain powers. And a couple of years ago, our legislature amended our power of attorney rules and included what we call hot powers. So these are powers that, although not presumed, were common enough that they wanted to include in the statutory format. And so we call these hot powers, and we include these in many powers of attorney. And this is a decision you would need to make in deciding whether you want to include these expanded powers in your power of attorney. And you'll see that they're very, very broad. So the ability to create an inter vivos trust, that's a living trust. We often hear reference to revocable living trusts, and James did a session last week on wills versus trust. So this would be one of the types of trusts he talked about last week. That session also is on our YouTube channel if you want to go back and watch that. Also, with these expanded powers, the agent, the representative, can prepare or implement or amend rights of survivorship, beneficiary designations. Also, they can make gifts on your behalf under the power of attorney. And finally, your agent can even, if they've been given this authority, they can even name different successor agents behind themselves. So for example, if I'm a representative, an agent for someone under their power of attorney, I'm ill or I'm traveling and I just can't or don't want to serve anymore, if I had this power, I could name my own successor. Again, these are very broad powers, very good, very powerful in the right hands, and very, very dangerous in the wrong hands. So we always encourage clients to look very carefully at whether they want to give these expanded powers. And it's not an all or nothing. So you could look at some and say, yes, I want to give that, but no, that one makes me nervous. So look at them one by one and decide whether they're right for you. I will say though, we serve clients of all ages, from young adults through the end of life. And especially as we have clients who are aging and perhaps looking at a need for long-term care. A lot of those clients are looking for qualification for Medicaid that helps pay for nursing home care. And often for Medicaid qualification, we need to move assets around or change beneficiary designations so that we don't have assets going to someone who is on benefits or needs to qualify for benefits. So these powers, the gifting power, the ability to name beneficiaries and survivors, are very, very important, but very powerful, and they can be used to upend a person's estate planning in the wrong hands. So it's very important that you have absolute confidence in your agent if you're giving them these powers. Also understand that this gifting power in this list is still limited. It doesn't state a limit here, but it is limited to a certain dollar amount under the Texas Code. So especially for our clients who are looking at a possible need for long-term care, we really broaden that gifting authority very broadly so that it doesn't put any kind of dollar figure or limitation on who can receive those gifts. So again, powers of attorney can be written very broadly. In the wrong hands, that's very dangerous. In the right hands, very powerful and gives us a lot of flexibility in planning for the particular needs of a client. So continuing on with the power of attorney, we talked about that power, and it can be very dangerous in the wrong hands, but I want you to understand whether you're signing a power of attorney, giving someone else the authority to act on your behalf, or perhaps you're the agent for someone else under their power of attorney, it's very important to understand that the agent, the representative, has what we call a fiduciary duty to act on behalf of the principal. Now, again, the principal is the person who signed the power of attorney, giving someone else, their agent, the ability to act on their behalf. But that agent has a fiduciary duty to act for the benefit of the principal, not of themselves, in dealing under that power of attorney. So if I'm an agent for someone else and I'm using their power of attorney, I'm obligated to look out for their interests, not my own, in dealing with that power of attorney. That fiduciary duty is broad. It includes, under statutory provisions, both a duty to inform and a duty to account. And we have that broken down here. So the duty to inform basically says that I, as the agent, always have the obligation to keep the principal informed of what I'm doing on their behalf. Again, I have very broad power, especially if it was an immediate power of attorney. Maybe I'm handling all of someone's bills, handling transactions for them. I have the obligation to keep them reasonably informed of what I'm doing on their behalf. Also, I always have to be prepared to account for what I've done. Now, in addition to kind of keeping the principal up to date and informed on what I'm doing, that principal can ask at any time for a more formal accounting and say, hey, Elisa, I want to know exactly what you've done, where that money's gone, how it's been spent, where it's been deposited. We need to track that money dollar for dollar, those assets dollar for dollar, to make sure that I'm doing my duty and I'm following my fiduciary duties to the principal. So I have to keep very close records of everything I've done so that I can produce those records to the principal if the principal requests those records. Likewise, let's say the principal at some point has a guardian, or maybe they've passed away and an executor has been appointed for their estate. I will likely have to account to those people as well if they ask for an accounting. Likewise, a court can ask for an accounting for what I've done as the agent under a power of attorney. So the agent always has to keep in mind that fiduciary duty to act for the benefit of the principal, not for themselves. They have to keep the principal informed of what they've done, and they always have to keep very close records so that they're ready to make an accounting whenever that time comes. Continuing on with that fiduciary duty, when we talk about the obligation to look out for the interests of the principal, not of themselves, the agent needs to keep in mind that they have a general duty to preserve the estate plan of the principal as much as is reasonably possible. So if the principal has created a will, has created beneficiary designations, has kind of mapped out where they want their estate to go when they pass away or who they want to take care of during their lifetime. Likewise, that agent under power of attorney has an obligation to preserve that overall plan or overall scheme as much as is possible. Now, there are things that change in life. Who would have thought in January that we'd be under the circumstances we are right now with coronavirus? And likewise, as I age, my needs will change, my assets will change, my priorities will change, the needs of my husband and my kids and my family will change. Perhaps my need for long-term care will change. So saying that what I do right now has to be preserved for the rest of my lifetime may not be practical, but they are factors that my agent has to take into account in dealing with my estate, in dealing with my assets, to make sure that we're preserving that overall vision for my estate as much as is possible. Texas law says in particular that the agent has to take particular factors into consideration, and those include the value and nature of the principal's property, their obligations to support someone else or to support themselves, Minimization of taxes. So it recognizes that in many cases, a principal has a tax motivation to move assets in a certain way or spend assets in a certain way to minimize property taxes, estate taxes, income tax, all kinds of taxes that can affect an estate. And likewise, long-term care needs. Obviously, those are a terrible expense, a dramatic expense, and can have a dramatic effect on a person's estate plan as they age. So very, very important factor here that we always struggle to keep clients informed of and understand, and also agents need to be very aware of these limitations. When a principal names, a person signs a power of attorney and names an agent to handle financial matters for them, they are not relinquishing control and handing it over to the agent. In other words, the agent, the representative, is not in charge of the principal. They are not their boss. They don't get to overrun and make decisions for the principal that are contrary to what the principal or the person wants for themselves. In other words, if I sign a power of attorney and I give that power, I designate an agent who can handle financial matters for me, I still keep all of my own authority, all of my own power. I'm just sharing that power, spreading it to my agent as well. So I can still make decisions for myself and I can still handle financial matters for myself, but I've spread that authority to my representative so they too can handle things for me. But they don't have the power to take things away from me. I've not relinquished any power to them. Now that is very different from a guardianship. With a guardianship, a court might determine that I lack the ability to handle my financial matters and might remove my power effectively and put that into my child or other representatives so that they can handle financial matters for me. So with a guardianship, I lose the ability to make some types of decisions for myself, and it's been placed in someone else, the guardian's power for me. On the other hand, with a power of attorney, I've not relinquished anything. I've just shared my power with the person of my choosing. I can revoke that power of attorney anytime. If you want or need to revoke a power of attorney, we recommend that you expressly do it with a new document, expressly revoking that prior power of attorney, that you also gather up any known copies of that power of attorney that are out there and destroy those. You need to ideally file a revocation with the county clerk, just in case a copy of your power of attorney was recorded or might later be recorded with a clerk. It's good to have a copy of that revocation recorded with the county clerk to limit the ability of your representative to handle real estate transactions for you. Also, if you commonly do business with a particular bank or brokerage house or any third party that you have a business relationship with, we recommend that you expressly notify those third parties that that previous power of attorney has been revoked. And finally, this is probably first and foremost, you have to tell your agent, your representative, that your power of attorney has been revoked, therefore they no longer have the ability to act on your behalf. If you don't tell that person that you've revoked the power of attorney, then they can still rely upon it and continue to act on your behalf. Now, again, they have a fiduciary duty, so hopefully they're not doing that to your detriment, but they can continue to act until they know that their power of attorney, that the power of attorney you signed naming them as an agent has been revoked. So very important. Sometimes people may have a level of distrust and they want to revoke a power of attorney, but they're bashful about telling their agent, and that just doesn't do the job. The agent has to know that that power of attorney has been revoked. So again, agents, you cannot be heavy-handed in working with the principal. They are still in charge, they are still the boss, and they can revoke that power of attorney as long as they have capacity to do that. All right, continuing on with powers of attorney in general, let's look at medical powers of attorney. Everything we've talked about so far has been the financial power of attorney. We're going to shift gears dramatically here to the medical or healthcare power of attorney. So with a healthcare or medical power of attorney, you've named who can make medical decisions for you if a time comes when you cannot make your own medical decision. Now understand that my inability to make my own medical decisions might be permanent or might be temporary. So for example, if I have dementia and my condition has declined over time and it's not going to get better, then that's a permanent condition. And my agent, once they have power to make decisions for me, their power is going to continue. But my inability to make medical decisions could be temporary. It could be that I've had a knock on the head. And so as long as I'm loopy, my agent, in this case my husband, has the ability to make decisions for me. But once I recover, his power goes away. Perhaps I'm in surgery or under anesthesia. While I'm unable to make decisions, he has power. Once I recover, his power goes away, and I alone have the ability to make the medical decisions for myself. So medical powers of attorney, it's important to understand that your agent only has the ability to make decisions for you if you cannot make them yourself, but that inability can come and go according to the moment and according to your capacity and what's causing that inability. Understand that you alone, again, I just said this, but I want you to understand that you alone have the ability to make medical decisions for you. So let's say that I've been given a very discouraging diagnosis and I don't want treatment. And my doctor says, well, that's crazy. We think we could make strides with this treatment. And perhaps my husband and my kids really, really want me to get the treatment. But if I'm rejecting it and I'm doing that out of an informed decision, then I alone have that ability to make my decision. Likewise, if I later lose the ability to make my own decision and my husband steps in as my representative, he's obligated to make decisions according to what he knows my wishes to be. So if he knows, and especially if my doctor knows, that I don't want a particular treatment or don't want particular care of some sort, then he cannot legally authorize that treatment, even if I've lost the ability to express that myself. If my representative, if my doctors don't know what my preferences are for a particular treatment, then they simply are obligated, my representative, my agent, makes decisions according to what he or she judges to be in my best interest at the time. Now again, agents, we talked about this earlier with durable powers of attorney. We recommend a sequence of agents. So agent number one, if he or she can't act, we go to the second one and the third one and so forth. Again, clients sometimes ask, can I name co-agents? Legally, yes. In practicality, we really, really, really discourage co-agents on a medical power of attorney, especially with medical decisions. We really encourage you to have one agent at a time so that if a decision needs to be made, doctors have one person to go to without having to wait through a consensus among family members. One of the greatest values of a medical power of attorney is we're designating a particular person who can make decisions for you in a crisis, and we've really diluted that effectiveness if we have co-agents. We're back to having to get a consensus, and that can be very difficult, especially when a difficult decision needs to be made. So we really, really strongly recommend one agent at a time on the medical power of attorney. If you have co-agents, you need to assume that they'll have to come to a consensus in making a decision. And again, that kind of sounds warm and fuzzy as a parent. We want all of our kids to work together in making difficult decisions like that. But in practicality, we kind of need one spokesperson who really has the ability to make a decision. That kind of wraps up our prepared comments today. If you would like a copy of our PowerPoint, please feel free to email marketing@raineyandrainey.com. Christina Swanson is one of our team members here, and she would be happy to send you a copy of the PowerPoint presentation. We have some questions that have been sent in by chat, and so we're going to take a few minutes to look at those and try to get some responses to those. So if you have some more time, please feel free to